Confidentiality and the Duty to Warn by Sarah-Jayne Ames. In this presentation, I will discuss the ethics and laws of confidentiality. I will discuss the famous 1968 case of Tarasoff versus Regents of the University of California. I will also share the American Counselors Association relevant codes of ethics. Then I will share a case study that expanded the perimeters of the Tarasoff law. And in conclusion, I will show both sides of the verdict on whether the limit to confidentiality hurts or helps the therapeutic relationship. There are many reasons a person seeks professional psychological help. These can include depression, anxiety, adapting to new changes, and difficulties in interpersonal relationships. Other reasons may include loneliness, suicidal thoughts, substance abuse, feeling out of control, or experiencing stress. Some people may have an eating disorder, PTSD, or have experienced the loss of a loved one. Some simply just need to talk to someone with a fresh perspective. If someone seeks therapy for any reason, they need someone they can trust. They also expect the counselor to keep their issues confidential. The ACA Code of Ethics states, quote, "Counselors do not share confidential information without client consent, without sound legal or ethical justification," end quote. In personal relationships, it is morally correct to keep friends and family's confidences. As a professional, you are legally bound to do so. W.D. Ross, 1930, created duties for professional healthcare workers. They include non-maleficence, beneficence, justice, fidelity, and autonomy. Non-maleficence is to do no harm, and beneficence is to do good. It is obvious that our client is our priority and who we are duty-bound to protect. Wedding and Corsini, 2018, claim that the therapeutic relationship is the most important part of success of any type of therapy. I agree that the client-therapist relationship is crucial to the success of therapy. When there is a deeper trust, a client will disclose more. When the client feels free to share deep emotions, the therapist has a greater ability to help. The ACA Code of Ethics covers both privacy and confidentiality. They expect counselors to be culturally sensitive, as different cultures view confidentiality differently. They also advise to have ongoing conversations about confidentiality and the limits and times it may have to be breached. If information is to be shared, the client has a right to know with whom and what information will be shared. For privacy, it is expected that counselors will only, quote, solicit private information from clients only when it is beneficial to the counseling process, end quote. But what if your client shares information that they plan to harm themselves or others? Should you keep the client's secrets, or should you warn those who may be in danger? The ACA Code of Ethics gives exceptions to the client's respect for confidentiality. A counselor has a duty to warn and breach confidentiality if he feels there is, quote, foreseeable harm, end quote, to a third party, or when, quote, legal requirements demand it, end quote. This section also includes releasing documents for legal purposes. Other exceptions to confidentiality include if the client intends to spread a, quote, disease commonly known to be both communicable and life-threatening, end quote. The court can also subpoena records without the client's permission. This information should be the least necessary to inform the court of what they need to know. When a counselor is in training, they may need to consult with a supervisor. The client should be aware of everyone involved and what is being shared. There are other issues in confidentiality, but I am going to focus on the counselor's duty to warn and protect. I mentioned the hippo in the room. The Health Insurance Portability and Accountability Act of 1996, known as HIPAA, refers to both paper and electronic transmissions of records. It involves informed consent and how records are transformed or transferred and who can have access to them. Schleicher, 2017, claims that the HIPAA Act of 1996 overrules conflicts in court and allows disclosure of information based on a serious and imminent threat. These rules try to maintain a balance of protecting confidentiality, but also warning or protecting the community of the danger that the client possesses. The ACA codes mention that a therapist can breach confidentiality if they believe there is a foreseeable harm to a third party. Research by MacArthur found that, quote, the only population for which accurate assessments of risk can be made are those who are acutely psychotic, usually paranoid, active substance abusers, or who recently committed an act of violence, end quote. The issue with these standards is determining foreseeable harm and knowing if the threat is plausible or if the client is just frustrated. If you are unsure if a threat is real, here are a few things that Wheeler and Bertram advise. I will give you some time to review them. In California in 1968, something happened that changed the therapeutic relationship forever. It is called the case of Tarasov versus Regents of the University of California. Donald N. Bursoff describes the case. He explains that President Poddar was raised in India and was part of the Untouchables caste. In 1968, he was living in California and attending university. He met Tatiana at a dance and had been seeing her for a couple of weeks. She kissed him on New Year's Eve, and he saw that kiss as a commitment and later asked her to marry him. This made her reject him and tell him she was dating other men. Poddar became obsessed and replayed conversations he had recorded over and over, trying to figure out why she did not love him. His roommate, who also happened to be Tatiana's brother, suggested he should go to therapy. Poddar attended all his sessions and repeatedly told the therapist that he wanted to kill Tatiana. Even though he did not name her, she was readily identifiable from the details that he provided. When the therapist threatened hospitalization and to tell the police, Poddar terminated his therapy. His psychologist, Dr. Moore, told his supervisor of Poddar's threats, who informed the campus police. Poddar was interviewed with his roommate present and denied the death threats that he had made. He was never hospitalized, and all documents concerning his therapy were destroyed on the promise that he would stay away from her. Just days after meeting with the campus police, he went to her house and she refused to speak to him. She tried to run away, but he chased her and stabbed her to death. After he killed her, he called the police from her home. He served 5 years after being convicted of second-degree murder. His case was appealed in 1974, and he was deported to India. In India, he married a lawyer and is living a normal life. As a result of this verdict, the parents sued the Regents of California, which led to the extension of a counselor's duty to warn. Now counselors are liable if they fail to warn the third party if they are in danger from their client. The California Supreme Court ruled that defendants, meaning the counselors, could not escape liability on these grounds. Instead, the court ruled that, quote, when a therapist determines that his patient presents a serious danger of violence to another, he incurs an obligation to use reasonable care to protect the intended victim against such danger, end quote. Since the verdict, 33 states have adopted similar laws. In Illinois, the law has changed slightly. It allows the therapist to use discretion on whether to break the client's confidences in similar circumstances. Because laws differ state by state, the best practice is to know your state law. Kegel et al. Explained that many states have laws that protect the therapist from liability if they follow the procedures set by the state regarding confidentiality and the duty to warn. Some of these procedures include notifying the police, the victim, having the client committed, or having a treatment plan with the client to eliminate the threat, and reporting the threat to a higher authority. What constitutes an imminent threat? It is hard to determine if a client is an imminent threat. Kegel et al. Proposed some indicators which include criminal history, impulsiveness, age and gender, alcoholism, and drug abuse. The therapist must ask questions to find out if the client has a means to commit the act. Do they have a plan? Is there motivation? How much stress are they under, and if they are making a clear threat? It is good practice to know the history and current mental status, but having a criminal history is not always relevant. Poddar had no previous criminal history and was dismissed by the police after promising not to hurt Tatiana. If a therapist has any doubt, they should seek consultation and consult with lawyers. In non-serious threats, the therapist can work on a treatment plan to eliminate the threat and work with a psychiatrist for medication. Most responsibility to warn is based on if the threat is clear. Have they identified a victim? Is there a solid plan? And does the therapist believe the client is likely to carry out the threat? If it is a casual threat without specifics, a therapist could consult with a supervisor and monitor the situation to see if it escalates. The best procedure is to document every step that you take. The terrace of law has made confidentiality in counseling less secure and less appealing to a client. Not everybody believes the terrace of law is effective in helping to save victims from danger. In fact, Bossoff disagrees. He argues the terrace of law is a, quote, bad law, bad social science, and bad social policy, end quote. He believes that the duty to warn laws that have resulted from the Tarasov case can lead to clients not telling counselors if they have violent thoughts or intents. He suggests a discretion to disclose, just like the Illinois law. He feels it's more appropriate, and this allows the counselor to choose other options such as hospitalization or consultation before informing victims or police. He agrees with the dissent of the California Supreme Court. They said, quote, "It becomes clear the duty to warn imposed by the majority will cripple the use and effectiveness of psychiatry. Many people, potentially violent, yet susceptible to treatment, will be deterred from seeking it. Those seeking it will be inhibited from making revelations necessary to effective treatment," end quote. The opposite opinion, which was the winning verdict, is that the public have a right to know if a credible threat has been made against them and to be protected from it. Bossoff gives several suggestions for therapists with potentially violent clients that are not an imminent threat. They are to seek consultation, recommend voluntary hospitalization, extend the session of therapy to talk through the problem, refer for medication, and lastly, give the client a chance to amend or to confess. He claims lawyers' rules of conduct are given discretion to report. So why can't mental health workers have discretion also? One of the issues Bossoff had with the therapists that worked with Poda is that no regard was given to his cultural background. He suggests that Tatiana may still be alive if Poda was not threatened with hospitalization or disclosing his statements to the police. He claims that the therapist had worked with him for another 2 months. He may have been able to work through Poda's issues. The untouchable class of India are the lowest of the low and not even worthy of being a part of a caste system. They clean feces and dead bodies and are persecuted and despised by the other castes. Poda came from this to America. He probably had no idea how to handle a relationship or Tatiana's affection to him, and it meant something different to him in his worldview than it did to hers. Corey et al. Talks about understanding the context of culture in a person's behavior. Quote, "The individual or group's culture play a central role in understanding their behavior in context," end quote. Bossoff concludes the psychologist failed to culturally assess Poda, and instead of threatening him, he could have worked with him and avoided the death of Tatiana. My question to you is, how would understanding Poda's background and his insecurities have helped Dr. Moore to respond differently to his threats? Would it have made any difference? Why and why not? Schleicher, 2017, describes a Washington state case, Folk versus D'Amelia. Folk was diagnosed with bipolar and started to see a therapist in 2001. He continued intermittent care throughout the years, during which he went through several life-altering events, such as a divorce and insecure jobs. He did not take his medication regularly, and he went for long stretches without seeing a therapist. The client expressed suicidal and homicidal thoughts during his sessions, but never acted on them. Life seemed to be improving when he found a girl who he shared a child and a home with. In 2010, just 2 months after he had last seen his therapist, the man killed his ex-wife and one of their sons. The other son was badly injured. The therapist was sued because the family claimed, quote, "The homicidal and suicidal behavior was foreseeable and preventable," end quote. The Folk verdict broadened the scope of the duty to warn. It now included any foreseeable victims, not just those readily identifiable. This impossible standard has been criticized by many who claim the standard is impractical and impossible to know the extent to which a therapist must report and how to report if the victim has not even been identified. My second question is, what issues do you see with determining foreseeable offense versus reporting readily identifiable ones. In regards to the transmission of dangerous diseases, the ACA Code of Ethics say that when clients disclose that they have a communicable and life-threatening disease, counselors can be justified in warning an identifiable third party. If they feel they are at high risk of contracting the disease, prior to making a disclosure, counselors need to confirm that the diagnosis is real and what their client intends to do. Will they share information about their disease or try to engage in behaviors that may be harmful to an identifiable third party? My question is, how is it possible to notify people that may be at risk from your client's behavior? If they're in a long-term relationship, the therapist could work with the client to tell their partner. If not, is it even possible? Sometimes a client will come to you with suicidal threats. Corey et al. Provide a guide to assessing suicidal behavior. They stress that you must always take verbal warnings seriously, and you have a duty to warn and protect. Here are some of the ways that they suggest you could detect suicidal behavior in a client. Here are some more. With regards to child abuse, if an adult mentions harming a child in the past or a desire to do so in the future, the counselor is duty-bound by most states to report it. Corey et al. 2019 explain if a child in therapy expresses a desire of self-harm or to hurt others, the parents are to be informed. In the case of hurting others, police, the potential victim, and the families are to be told. Even though this has potentially saved many lives, Corey et al. Argue how many lives could be saved if the child knew that they could talk to a therapist without being snitched on. Do clients of all ages who have thoughts of harming themselves or others avoid therapy because of the fear of being hospitalized or contained against their will? Maybe they could work through issues with a counselor trained to de-escalate situations if they were guaranteed confidentiality. Curry et al. Claim that minors who are informed of the limits of confidentiality, quote, can result in the child no longer trusting the therapist, end quote. So how do we create a happy balance between gaining trust of our client and keeping the community safe? With all these rules and regulations on confidentiality and the duty to warn and protect, a counselor may become overwhelmed. How can they gain a client's trust when they are duty-bound to breach confidences if they detect a foreseeable threat to another person? I agree that the community needs to be protected from danger, but I also believe that foreseeable is too broad a scope. I think it should be discretionary, like the law in Illinois. I also believe that the threat should be serious and identifiable to be reported. 2008 and 2016 suggests a 6-step model to protect the rights of a client's confidentiality. They are preparation. Make it a standard at the beginning of your therapeutic relationship to have informed consent. This is a contract that needs to be simple and understandable. It must explain the limits and exceptions to confidentiality. This is a living document, and it is between the client and the counselor. Allow the client to ask questions to make sure they understand everything. Review the contract several times during your therapeutic relationship. The next step is to tell the clients the truth. Always explain the limits you will impose and ask the client to agree or not. Obtain a truly informed consent before disclosing voluntarily. If pressed to legally inform, ask client to sign consent before disclosing. The next step is to respond ethically to legal documents or demands for information. Inform the client of the pending disclosure and only disclose what is necessary for legal purposes. This applies to information needed for court cases and such. It also applies to consultations with supervisors. Only the important and impertinent information should be shared. Avoid preventable breaches of confidentiality. Empower your clients to take responsibility. Do not confuse the laws that permit disclosure with laws that require disclosure. That was by Fisher. I love that he distinguished between permit and require. The last step is to talk about confidentiality with clients, colleagues, lawyers, and judges. and with the general population. This part relates to the advocate duties of a counselor. Discover how the law helps or impedes the public. Educate others on what you discover and be willing to have an open mind. In conclusion, the client has a right to confidentiality, and exceptions should only be made if you feel they are in danger to themselves or to others. Always have informed consent, which clearly states the limits of confidentiality in a language the client understands. Throughout therapy, review the contract. If threats are made to do anything, you can help the client, even if it means you must prolong the session until you can really determine what is going on. If information is demanded by courts, share the information, but the minimum that is needed. All efforts must be made to help the client. If possible, seek the client's permission to share and what to share. I believe it is possible to gain a client's trust if they know that they are your priority. If they understand breaching their confidence is a last resort you want to take, and only will be done if they needed help to prevent them from doing harm to themselves or to others.